Greetings and welcome to the Judicata podcast. My name is Taran Chittapalli and I am the host for today. Today, we're joined by somebody whose work has consistently shaped how international law is applied and understood in real-life situations and in times of crisis. He is a professor of international law at the Roma University. He has a plethora of work experience, some of which include being serving as a judge at the NATO's Missions Tribunal and has also worked with the International Committee of the Red Cross. His work is a combination of both academic depth and practical experience in some of the most intricate areas of international law. It's a real pleasure to have with us today Professor Giulio Bartolini. How are you doing?
Fine. Thanks for the kind invitation.
And so how's your time been in our city?
Oh, fantastic. I'm here for this conference on the Bhopal tragedy, and of course, I'm quite interested about the legal implication of disaster. So that was definitely a place to be for this conference.
Okay, sir. And today we'd love to not just know about your work, but also about your experiences, some moments and experiences of how your knowledge about international law has been shaped, and also what you think the law's requirement is in today's world. What aspects of this law drew you to it? How was your journey into this law? And do you think it was something that you always wanted to do in the first place?
Which makes me reflect why I joined this work. Mainly because I would like to be an academic, and during my studies, and I studied political science. So I didn't study law, even if in Italy political science at the time had a strong combination both of historical aspects, which also I like quite a lot, and the political science, but also law in different international and domestic components was also part of the degree at the time and so forth. During the time I was fascinated by international law, and so I started to focus a bit more on that also during my Erasmus period when I was just spending some months abroad for some early activities as an exchange student, and I also followed some courses in international law at the University of Bristol after having done them also in Siena, where I originally got my degree. So I could also see a bit of difference in the approaches between two jurisdictions on how international law is conceived. So it also fostered my interest on the subject, and then I started my PhD on that, and that's the start of the journey.
So there's so much that is conceived from different jurisdictions, and there's so much that people from different places perceive it. But just I've always had this question. Let's say I'm from India, right? So is there a tension between one's national identity and how they perceive law? And have you ever faced such a tension on how you apply the law or understand it in the first place?
No, that's clearly a huge point, because of course it's true that international law is or should be a global language, but at the same time it's speaking with different dialects in different places of the world. Because of course other legal, institutional, but also historical component might shape how international law has been perceived, has been thought, and has been applied in the different components. And I think the national dimension of international law is a key factor, because of course international law is already said one of the first causes of the kind of international law. There was this quite famous metaphor according to which international law is like a field marshal, which will not work unless the orders of the field marshal are applied by the generals and then in the field by the other actor. So this metaphor, which is present in one of the early courses of the Hague Academy 1 century ago, I think is still relevant nowadays, in which international law could only work whether it has a meaning and has support on domestic level, for sure.
A lot of my colleagues and my batchmates, we've all had interest in international law, but we also have several misconceptions about it. Were there any misconceptions that you had when you were entering into the field, and was there something that only got debunked once you got into the field and worked a lot in the field as you had a lot of experience?
Yeah, I think also the degree in which you enter into the field makes a strong difference. Honestly, when I started my activities with international law, if I compare that period, so which was basically end of the 90s, it means that in the early 2000, it means that it was a period in which international law was booming, and there was a lot of hope that it would really play a role for better world, for improving. Just take into account how my age, we came after the period in which there was the birth of the first international criminal tribunals, was Yugoslavia and Rwanda. Then there was, of course, WTO, which was set up on the same period. And there were multiple examples of activities through which we could think that international law could play a positive role. Then, of course, there were already at the time, for sure, all the structural inequalities which have characterized international law, which have been, of course, one of the major elements of concern and critique. But then at the time, I think more the positive trend, the positive mood there was experience. If you think about young scholars entering in the field nowadays, in which, of course, is a period where the international dimension is characterized by a fragmented multipolar scenarios of with pivot actors in different places, which of course are not very reliant on what was the stuff international at the time, which was much more influenced by neoliberal approaches, which, right or wrong, of course, gave a bit more post tone than is the current situation, of course, which is not just due to international law, but mainly to international relations, the more fragmented and divided world that we are experiencing now, which of course has then a need for international law, even if I will not say that is international law responsible for them.
So you worked a lot in the field of humanitarian law, right? And we as students have had some exposure to humanitarian law in the course of our course, right? So we have heard the term humanitarian law a lot, and I'm sorry. But I'd like to know a bit more about how it looks to you. Like if I were to shadow you for a day as a professional, as an academician, how would a day in your life look like in respect to how you deal with the law and how you teach it to your students?
Yeah, no, if you ask me specifically about international humanitarian law, of course, that's the law that if you use the usual parameter is that if international law is the vanishing point of law, then international humanitarian law is the vanishing point of international law itself, which is the famous quote used by a US scholar in the 70s or even earlier, I think, which of course might undermine the relevance of international law itself. At the same time, it's true that probably for that reason that international law must be applied at a time in which, of course, law is not the most valuable around the fighting parties. Also implies the need to work on it in order to favor its dissemination and implementation to create a culture of application for international humanitarian law. So, of course, the same fragility of the law itself, of fragile itself, might be perceived as a chance for it to foster our works and our efforts on that.
So I've seen that, as you said, right, international humanitarian law is applied when law is not valued that much. And it comes during some of the most intense times, such as war or some of the most criminal acts in anything. So how do you balance between being as analytical and as reasoned as a lawyer, and also at the same time being empathetic as a human being and as a professor?
Yeah, so that of course is an element which should be there. At the same time, I think, at least from a personal approach, it could be different way to approach the topic. It would be much more militant, much more aiming to fight for such values, which of course might bring you also to the side of more activism, or which is a bit more my approach, maybe also the personal character. I'm more interested not just to see how the law is, or which is just technical, which of course that's on merit, but it's not the main point. But at the end, I think on the contrary, even through a more analytic perspective, you can try to engage with this area. So just give you a few examples. I'm in charge since several years of the IHL activities of the Italian Red Cross, which basically has manage a set of some hundred volunteers specialized in IHL, which then make some classes to armed forces or to civil society, or also with my studied at the university, I use a clinical method to teach international humanitarian law, which try not only to reinforce, to give them some theoretical knowledge, but also to permit them to apply theoretical knowledge for areas or for partners like ICRC, Geneva Conventions, the humanitarian Red Cross, or some institution like NATO, which nevertheless must be requested to apply law. So the point is basically the need to use, I think, your technical skills also to, I wouldn't say favor a change because it's complex, but at least favor a society, the spread of the knowledge of IHL with the idea, with the hope that such spread of knowledge to different levels might finally contribute to a better application of the law or to a knowledge of the law itself.
Do you think that the treaties and the ways tribunals are now making the law effective is the same as it's written on papers and how it's being applied on the ground? Do you think there's a discrepancy of any sorts?
It's true that we say there is a difference between how you speak about international humanitarian law in the venues, then how you speak international law and you apply international law in the battlefield and by the person. So I think we also need different languages and different tools. That's the reason why, coming back to one of the previous questions, I think there is a strong still need to, let me say, permit IHL to be digested by those who need to apply them. So I think as an academic, we should provide support to institutions, could be your national Red Cross Red Crescent Society, there could be other NGO, or there could be even the armed forces, which I think each of them should benefit from a more cooperation with academics, and the opposite way around. Academics would not probably work without the proper technical knowledge of such stuff. But in order to make the law not, let me say, an instrument for lawyers to make a good treaty or nice treaty and then afterwards a nice paper in the international journal, but to make this law a language and a tool which is understood merely by those who need to apply them, because I think the effort of academics must be tried to develop tools or activities which might permit to really engage with the person who requests to apply the law, because in this case we don't have, let me say, the advantage is another area of law where we say, well, if there is an application, the first instance whether we Supreme Court reverse the judgment, now here a wrong decision is a matter of life.
Right, sir. And you've also had a long experience, as you said, with the International Committee of the Red Cross. We share a bit more about the experience and what you've contributed and how you learned from it.
The National Red Cross, the Federal Red Cross, has this focused. So I joined it, and it goes back to more than 2 decades ago, and I'm still working with them and with much more high level, I would say, profile now. But then, even if now I'm more working with the president, with the national bureau and stuff like that, the focus is still to transmit, to transfer the knowledge that academics, not just myself, but also a set of other academics, my efforts in Italy, might transfer to the volunteers, and then the volunteers might act as trainers for other person and for the person to apply. So that was one activity. Then, of course, I follow quite closely the legal activities of the National Society. I was, for instance, on several occasions nowadays as a legal advisor in the mission, in the delegation, which participated in the International Conference of Red Cross and Red Crescent Movement, which, as you know, is the 4 years meeting where we discuss about IHL. And then with the ICRC, of course, I cooperated mainly sometimes for instance, with the legal clinic, we cooperate a lot. So we develop a project in our legal clinic on IHL, which support ICRC activities. It could be for practice on the customer IHL study, but it could be mainly with another tool that I value a lot, which is named IHL in Action. That's a database where basically legal clinics from around the world, there are not so many, but there are some of them, collects real cases of application of IHL. So the idea of the database was to create a scenario in which basically through 4 or 5 open document, you can demonstrate that this state or this organizing group in this specific instance applied IHL properly because, and then you have a series of questions. You can use this material in class for discussion with students, but also with mainly, I would say, with armed forces to present the material to them. Because the idea is that we should work in order to explain how this law is not only relevant, but it could be applied. It has been applied, and so there is no reason why you would ever use not to apply it, except that you don't want to apply it.
So I imagine your work just does not include, let's say, understanding the law, but it's also about shaping the law and applying the law. You've held a position as a scholar, as a professor, and also in several adjudicatory roles, such as being the judge at the NATO Missions Tribunal. How do these experiences feed into each other? How does one affect the other?
Yeah, this tribunal is quite new, let us say, new actor in the specific area of international law, which is international administrative law. So basically, in this case, international organization, as they basically, due to their immunity, will not bring to national court, it does not mean that the actors and the person working with them should not get a specific redress. So basically, since almost 1 century, international organizations have started to develop their own international administrative tribunal. NATO already had one of them for the main workforce, which are basically the civil servant of NATO. But then what's happened for NATO to carry out a series of military mission abroad, that was particularly for Afghanistan at the time, but also the Balkans, Iraq. There was a lot of reliance on local force, local workforce, which of course should also get, in light of rule of law, a proper access to a judicial remedies in case of the decision made by. So NATO was not fit for purposes. So NATO, in a wise approach, decided to set up this specific international Ministerial Tribunal, and then I was co-opted there and appointed along with more people with more practical and judicial experience, but also with some academic.
How do you think, when there's so many diplomats, so many, let's say, politicians, and so many other actors in place while such discussions are happening, how is it grounded in law? How do you keep the conversation grounded in law, and so that it doesn't diverge into other topics and other heated issues?
Well, if you speak about exactly the international research tribunal, that's easy because basically there we only have law to apply. It's very dry law, let you say. But then if you move to other contexts, like the international conference I was mentioning with you before, or another project I'm following quite a lot since decades nowadays, is, for instance, the current negotiation process for a treaty of the United Nations on protection of pets in the event of disaster, which is a potential treaty coming out from the International Commission of Articles on the same topic. And there, on the contrary, also just to have the idea to move from a potential recommendation made by the International Commission to the UN General Assembly to have a treaty. In the past decade, I would say, I've tried as much as I can from my expertise perspective, and also knowing, I've tried to foster the links between the different actors to push for the treaty, because the treaty, from my perspective, is might feel a gap in international law to facilitate a universal framework for facilitation of international assistance in case of disaster. But in that case, on the contrary, law is not the main. Well, law is the main component, but then other significant and equally relevant components are the diplomatic and political scene, in where also to arrive to this final decision that was adopted recently to establish a demand conference to negotiate the treaty in 2027. It took years to discuss it, to create a positive environment, and then other elements facilitated the final solution, the final result, like the presence of other potential treaties to be negotiated, which were more of interest for some states. The treaty on disaster more of interest of other states, and so there was some diplomatic political bargain to arrange. There you can clearly see how even to reach the point of discussing and negotiating the treaty, it's not sufficient to say, well, there is a legal gap to cover, let's cover it. No, you need to create a positive and proper demographic environment to have the chance to discuss it, because regardless of how good or how worthy might be a legal point to be addressed by the international community, if there is no political consensus behind it, there is no chance to move ahead. So, of on that, also civil society might play a pushing role, but of course, states are still the major actor.
You also said that you're working with the United Nations and on a treaty, right, the recent one. Where do you think the real test for such treaties, man? Does it depend on, let's say, respect to the drafting, or with respect to how it's applied and when it's affected on the people that it's actually supposed to be to them?
So, in that case, I started to work on the project when I was legal assistant, the UN special rapporteur on the topic of prevention for creative disaster, which was a former international civil servant, Eduardo Valencia Spina, was very well regarded scholar from Colombia. And, it's also interesting also for you as a young generation to see sometimes things happen in a very unusual manner. I was just in a conference on the topic. He was there. Then I was asking him. We started to chat. I was interested because in the topic already of the disaster and legal implication, and he was very open person. So what characterized Eduardo Valencia Spina is that he was very open mind. So a lot of else did not have a lot of institutional support, because the international law commission is member, even the special rapporteur work mainly on themselves. There is no UN dedicated staff apart from some support, work support provided by the International Law Secretariat. So, or they have already their own team, or they need to create their own team. And so there are some members who are very open to create a team where they can pick up experience. And in my case, he was happy that I wanted to support him, and I started supporting quite heavily in the last years. We really worked shoulder to shoulder on the project, and then after the project was adopted, I continued to support the idea of the treaty in this area. But apart from my own effort, which would be worthy or not, that's not relevant. But the main point, I think, is that sometimes that even interesting things might happen actually randomly. So my suggestion also for the young generation is to engage as much as possible, try to engage with some more senior person, which sometimes could work, sometimes could not work, doesn't matter, but at least there could be a chance.
So talking about the younger generation, I want to steer the conversation a bit into your academic experience as a professor. As our generation now lives on social media, we've seen so many other things that a time 20 years ago wouldn't have been there. So how do you think the way students perceiving international law has changed? How do you think students now are looking at international law? How do you think your way of teaching has changed according to that?
Yeah, so for sure, what I can say in a couple of decades is part of course it's a radical shift. So let me say, when I started to work, at least in continental Europe, this vision so limited. Some theoretical approaches were not. It was very more still quite traditional doctrinal approach, which is still irrelevant, at least in continental Europe. But then can easily see in a couple of decades what's the new generation growing up, and in some area clearly, at least in Europe, endorsing if was a critical approach, which is nowadays, at least in some conference, the mainstream. So if at the beginning critics were a bit of out of the radar on the content, now I would say in some academic venue, they are the mainstream. It's almost, let me say, impossible to find more doctrinal traditional scholars speaking in some contexts which are more prone to accommodate the position of a critical scholar, which of course have their own merit, because it's just a legal method, does not have any added value than any other legal method, which almost count the same. So for sure, this also shape part of the new generation because they are more exposed than I was in my own generation to a critical lens toward international law. And of course, there are a significant, I would say for sure, it's a difference where you learn international law because, of course, the background of the professor that teach you make a big difference. Then, of course, you can let it, like, you can go by yourself, you can change your methodological approach, or you can be curious about different methodological approach. But then I think the imprinting is still the most significant one. And of course, this makes so. As for the new generation, I'm pretty sure how more critical or even sometimes reinforcement regional approach are playing a role in giving new ideas, provide every time I say that it's not relevant just to destroy the law, but it's first relevant first to understand the law, to be able to work with the law, and then you can also contribute to change the law. But if you just jump on the critical side, on the destructive side, it's quite easy. But then sometimes we might miss the technicalities where basically your law is not the law which is relevant for the practitioner, which is an audience that we need to engage if we want to change the law.
So you yourself are part of several reputed journals as an editor-in-chief, right? So do you think this critical approach that you're talking about will be complemented by engaging in more editorial work and by publishing a bit more? What do you think is the role of such journals and editorial work in the current generation for us now?
So legal journal, of course, play a role. They also play, as we know, let me say, a dominant role, because basically it's clear that legal journal, even international legal journal, are also an object of power, because of course they publishing some more respected legal journal might permit you to have easier access to academic professional activities. So it's clear that journals are also an element of power, which has, of course, its own pros and cons in terms of the possibility to use them to facilitate a certain dialogue, to be open, or on the contrary, to try to remain close in some theoretical approaches without disregarding the other one. Currently, at least for international law journal, I think they are quite open, so you can find a venue for any sort of methodological approach. I would say the most well-known now, the shift is definitely on more the critical approach. I would say it's much more sometimes easier to publish in very well-respected legal journal if you have a more critical approach than the traditional doctrinal approach, which is still strong in some legal journal, but is not any more popular or fancy in other legal journals. So this also, of course, will contribute to shape also the academic sphere, because then it facilitates certain legal trends to get prominence. But then, of course, I think if the piece of research are good, they are good regardless of the legal background behind it. The problem would be if legal journal starts to favor a legal approach, the legal approach just because it's a legal approach, regardless of the merit of the content of the paper. That's, I think, a moral responsibility of the editors to keep the bar of quality high and not just to use legal journal to favor one approach rather than the other, regardless of the merit of it.
Coming to the final question here, I just want to understand for you, sir, and if there are any recommendations that you want to give with respect to the books that we should read, or any book recommendations that you would have for us to get a better understanding of the law and to have an entry towards it.
No, I basically say I'm not the person who will say, okay, that's the book which will reveal you what international law is, how it should be. So I'm not the person who recommend you a specific or some specific titles, because I think at the end, it will bring you back to the narrow approach in which you are guided. I think all the new generation is able to find their own, should be able to find their own perception, their own approach, what they would like the most, and of course what we can What I must, on the contrary, suggest so is not to give you a trajectory in terms of scholarship, which of course would be also my risk to bring you on some wrong direction because this will not be fit for you, will not be your approach. On the contrary, what I might suggest you is to open yourself in terms of exposure to different approaches, be in terms of theoretical approaches as well, but also trying, as you said, to collaborate as much as possible. Also, let me say, the podcast to manage is impressive because there are not so many like this one, and this is a good vehicle also for you to cooperate. The other one, of course, is to work a lot also on soft skills like coding presentation and also to present themselves. It might looks like a stupid suggestion, but also be able to present an international conference or national conference is something that you need to train for, which means timekeeping, which means to go to the main point because you will never be able to cover all the detailed and very sophisticated element you might have written in your paper if the time allocated to you is 8 meals. But it's 8 meals, you must force yourself to stay in the 8 meetings. You might be a silly suggestion, but it's also a matter to be professional, which is go back to the quality element that students might have, and then again never give up. So there was better fairness. Got the name. So it was one of the prosecutors, the military tribunal for Yugoslavia. He was Ben Ferenc, who basically passed away when it was more than 100 years ago, and the last part of his life, which was already an incredible life, he paid a lot of attention about the young generation, empowering them through a foundation under his name and so far and so on. And one of his motto was never give up. And he repeated it on a constant manner because it means that you fail, doesn't matter what is good, is to start again. And again, just that, because as I told you, some of the most at the end successful turning point in my academic career did not came out just because I stayed weeks or months in a library with my own laptop, but they came out because randomly I get in contact with this person, I met this other colleague, I send an email to this person asking for a suggestion, and so far and so on. So the network component is crucial, and you must force yourself not just to study, but also both to network as well as try to have some engagement with what you say. So at least in my experience, at the end of the day, you might give back something would be, I will not say to the society, so ambitious, let me say, a target for me, but tried as much as possible sometimes to put the law into practice, but not in terms of a lawyer, but in terms of try to make the law helpful for other people and also at least with the clinical activities around for the students to try to empower them to have a better chance of work in their career. So I think as an academic, we also have some duties toward the society as a whole, but also toward our students, not just giving the notes of PowerPoint, which are the same every year.
Thank you so much, sir. Thank you for sharing not only just your expertise, but also giving us a very unique perspective about how law is something so human, something that's so deeply necessary. And you've taken us through so many layers today. You've taken us through your journey. You've taken us through also about the spirit of keep taking this forward to the next generation today. So thank you so much, sir. We've learned a lot today. And are there any final things that you want to tell the students or anything that you want to tell the viewers today about your experience, your international, anything about the law?
No. Well, I think my final closing remarks were the biggest ones. So really, the idea, the hope, and the the trust that the new generation, where as you as a student, will definitely provide a good contribution for international law, and of course, but yes, in particular toward the new generation, because we are entering in a world, including a world of international law, which is different from the ones that with whom I started, which of course was more of a promise of a future, which nowadays, on the contrary, we are more in a dark side period of the history. But we hope that, regardless of how dark it could be, each of us might bring some small light, which at the end of the day might illuminate better the current situation.
Thank you so much, sir. Again, we've truly taken note about the fact that we should collaborate, cooperate, and take the law forward. Thanks so much.